Welcome to the Explainer. If you're prepping for the bar or you're just starting out on your feet, you know that evidence law isn't just some academic subject. It is the toolkit you use to win. Today, we're going to get into one of the most powerful and honestly, one of the most misunderstood tools in that kit. Okay, so let's set the scene. Imagine you're in the middle of a hearing. Your opponent is spinning a particular story, right? And you absolutely know there's someone out there who saw what really happened, a key witness. But for some reason, your opponent just isn't calling them. They're a ghost. So what does that mean? More importantly, how do you turn that into a weapon for your case? This is something you are guaranteed to come across, both in your exams and in practice.
Well, the way you handle this ghost witness situation comes down to one of the cornerstones of Aussie evidence law, and that's the rule from Jones v. Dunkel. So let's get into the nuts and bolts of how you can use this, how you can weaponize this in your own advocacy.
So, here's the core idea. If your opponent has a witness that they really should have called, someone who was right there, central to the story, and someone who's clearly in their camp, not yours, and they don't call them without a good reason, well, the court can basically say, I bet that witness wouldn't have backed up your story. It's a subtle but really, really effective way to poke holes in your opponent's case. Now, you can't just stand up and yell Jones v. Dunkel every time someone doesn't call a witness. It's not that simple. You have to earn it. And you do that by satisfying these three conditions. Think of it as your pre-flight checklist. 1, is this witness actually material? Like, do they really matter? 2, are they more readily available to the other side? Are they their witness? And 3, is there any good reason they're not here? You have to be able to say yes, yes, and no to those questions. This is pure gold for your exam, so make sure you lock this in. Okay, and this is where you can show some real sophistication. It's not just about what the rule is, but why it exists. And the courts have given us two slightly different reasons. The first one is the one everyone knows. We can infer the testimony wouldn't have helped them. Simple enough. But the second rationale? That's the more powerful one. It says the judge can actually become more confident in deciding a fact against the party who didn't call the witness. See the difference? One is passive, it wouldn't have helped. The other is active. This makes me more sure you're wrong. Nailing this distinction in an exam, that's how you get the top marks. All right, so a huge part of being a good advocate is knowing not just what arguments to run, but what arguments not to run. A flimsy Jones v. Dunkel argument will get you in trouble fast. So let's flip this around and look at the boundaries, the times when this rule just fails. And this quote from Justice Kirby just nails it. He's essentially saying, hey, let's use some common sense here. The point of this rule isn't to force someone to call every single person who was vaguely nearby to prove a simple point. If one good witness can do the job, you don't need a parade of 5 more saying the exact same thing. The courts are busy. They want substance, not just a tedious head count. So here are the big red flags, the main situations where this inference just won't apply. First, if the witness is likely hostile. Think about it. You'd never expect a party to call a witness who clearly hates them or has an axe to grind. It's also a no-go if the witness is equally available to both of you. You can't complain they didn't call someone you could have called yourself. And this is a big one. You can't force a party to call a witness blind. That is, if they genuinely have no idea what that person is going to say in the box. That's just not fair. And of course, if their evidence would just be repetitive, it's not material. Okay, and this is probably the most critical limitation, especially for your problem questions. The Jones v. Dunkel inference cannot create evidence out of thin air. It can't plug a hole in a case that's already sinking. If your opponent hasn't even made out a basic prima facie case, you can't use their failure to call a witness to build that case for them. Think of it like this. It can make a strong case stronger or a weak case weaker, but it can't turn nothing into something. Right? Now we need to shift gears completely. Because when we step into the world of criminal law, the stakes are so much higher, and the rules change. We're talking about fundamental rights here, the right to silence, the presumption of innocence, and these principles cast a huge shadow over how Jones v. Dunkel operates. And you see this incredible asymmetry in how the rule is applied. You can, and absolutely should, use it against the prosecution. If the Crown has a material witness and doesn't call them, that can be a huge deal. It could even lead to a miscarriage of justice. But trying to use it against the accused? Whoa, that is fraught with danger, and it's almost never allowed. And the reason is simple. It gets dangerously close to saying the accused should have proved their innocence, which flips the entire burden of proof on its head. And this principle is so important that it's protected by what we call a model direction. A judge will look the jury right in the eye and tell them something like this. The fact the accused didn't get in the witness box is not, I repeat, not an admission of guilt. Their silence doesn't help the Crown one bit. The burden to prove guilt beyond a reasonable doubt stays with the Crown from start to finish. It's a non-negotiable. Okay, so let's zoom out for a second. Remember that very first condition for a Jones v. Duncan inference? The witness has to be material. But what does that even mean? To answer that, we have to go right back to square one, to the absolute bedrock of evidence law, the concept of relevance. This is the first and most important hurdle that every single piece of evidence has to clear. Relevance is basically the so what test. Does this piece of information have a logical, rational connection to a fact the court actually needs to decide? Could it make one version of events seem more or less likely? If the answer is no, if it has no logical bearing on the case at all, then it's irrelevant. It's inadmissible. The judge doesn't want to hear it. So how do we figure out what's directly relevant? Well, one of the key tools we use is a fancy-sounding Latin phrase, res justa. Don't be put off by the Latin. It just means the transaction or the thing's done. It's basically a principle of completeness. It helps us draw a circle around the main event and figure out what's inside that circle and what's outside. And the best way to get your head around res gesta is this cinema frames analogy. Imagine an assault case. Is the relevant event just the one single frame where the punch connects? Or, to really understand what happened, does the court need to see the 10 frames before the punch, with all the insults being thrown, and maybe the 5 frames after? Res justa is what decides how many frames are part of that single, coherent story the court needs to see. Okay, so that's direct relevance. But let's be real, in most of your cases, you're not going to have a smoking gun or a videotaped confession. You're going to be building your case brick by brick, using indirect evidence, what we call circumstantial evidence. So that brings up a huge question, and it's a misconception that trips up so many junior barristers. Is a circumstantial case a weak case? Is it just second best?
The answer is a hard no, and this simple analogy shows you why. You ask your kid, "Did you steal the chocolate?" They look you right in the eye and say, "No, that's direct evidence." But they have chocolate smeared all over their face and hands. That's circumstantial evidence. Now, which one are you going to believe? Often, the circumstantial evidence is way more powerful than direct testimony, which can be mistaken or just plain dishonest.
So how does this work logically? Well, the law has a fancy name for it, a tacit syllogism. All that means is we take a proven fact and we combine it with a common sense assumption about how people behave. The classic case is Plump v. the Queen. The police are investigating Plump's wife's death, and before anyone even suggests it's murder, Plump blurts out, "I didn't kill her." The court's reasoning was basically, hang on, innocent people don't do that. That strange denial, that proven fact, combined with our common sense about guilty minds, created powerful circumstantial evidence against him. Okay, let's pull all of this together. We've covered a lot, from a specific tactical rule all the way down to the fundamentals. So what's your strategic edge? What do you need to take away for your exams and your practice? Here it is. This is what you need to know. 1. Treat Jones v. Dunkel like a tactical weapon, not just a textbook entry. 2. Show you're a cut above by mastering its exceptions. 3. When it comes to criminal law, know those warnings backwards and forwards. 4. Remember that relevance isn't a technicality. It's the art of telling a coherent story. And 5. Learn to love the circumstantial case. Argue its strength with confidence. Honestly, getting these things right is what separates the truly great advocates from everyone else. And that's it for this explainer. The big takeaway I want to leave you with is this. These evidence rules are not just hoops you have to jump through for an exam. They are the actual tools of your trade. They are the hammer and chisel you'll use to build a powerful, persuasive story for the court. They're how you get justice done. So the real question isn't whether you can memorize them, it's how are you going to use them to build your case.